down of such powers as may appear to be necessary or desirable for the purpose of enabling the said courts effectively to exercise the jurisdiction conferred upon them by this section or by any law relating to the hearing of appeals from the High Court. Parliament promulgated laws pursuant to powers conferred in that behalf in the Electoral Laws Act, in the Electoral Laws Act 2002, which were later repealed and replaced by the Public Elections Act 2012 as amended. Parliament also promulgated the Election Petition Rules 2007, which applied exclusively to parliamentary elections. But the history of the election process and challenges to the election of a president do not end with the 1991 Constitution. There was an interregnum between 1992 and 1996. The NPRC held the reins of government for 4 years. When a return to civilian rule was imminent, provision was made for the expected presidential election. The Presidential Election Decree 1995, number 17 of 1995, was promulgated by the NPRC and was used in the 1996 presidential election. Section 19(1) thereof provided that any person who is a citizen of Sierra Leone may challenge the validity of the election of the president by petition to the Supreme Court within 7 days after the declaration of the result of a presidential election under subsection 2 of section 15. Section 19(2) provided a declaration by the Supreme Court that the election of the President is not valid shall be without prejudice to anything done by the President before the declaration. Constitutional rule and democratic governance was restored as of 2nd April 1996. The Constitutional Reinstatement in brackets Consequential Provisions Act 1996, Act number 2 of 1996, was passed into law. By virtue of Section 6 By virtue of Section 6 of the Act, the Presidential Elections Decree 1995 shall be deemed to be an Act of Parliament enacted pursuant to paragraph B of subsection 2 of Section 42 of the Constitution and shall be construed as such with modification and adaptation as may be necessary. By virtue of Section 40, subsection 1 of the Electoral Laws Act 2002, any person who is a citizen of Sierra Leone may challenge the validity of the election of the President by petition to the Supreme Court within 7 days after the declaration of the result of the presidential election under subsection 2 of Section 38. Section 129 of the Act states, the following acts are hereby repealed: A, B, which do not concern us, and C, the Presidential Elections Act 1995. Then came the Public Elections Act 2012. Section 55 states, Section 55(1) states, a person who is a citizen of Sierra Leone and has lawfully voted may in a presidential election challenge the validity of that election by petition to the Supreme Court within 7 days after the declaration of the result of a presidential election under subsection 2 of Section 52. Now, Section 55(2) states, a declaration by the Supreme Court that the election of the President is not valid shall not prejudice anything done by the President before the declaration. By Section 168(1), the following enactments are hereby repealed: A, the National Electoral Commission Act 2002, and B, the Electoral Laws Act 2002. In the premises, since 1991, all matters relating to the election of a president have been the exclusive preserve of the Supreme Court. And for the purpose of clarity, the repeal of the Electoral Laws Act 2002 did not bring back into force the repealed Presidential Elections Act 1995. This is the effect of Section 18(1) of the Interpretation Act 1971. Act number 8 of 1971. It states, Section 18(1)(a), the repeal or revocation of an act, unless a contrary intention appears, shall not A, revive anything not in force or existing when the repeal or revocation takes effect. The intervention by Mr. Kuruma in the High Court also posed a much graver problem. Section 42(3) of the 1991 Constitution states, Section 42(3), a person elected to the office of President under this section shall assume that office on the day upon which he is declared elected by the returning officer or upon the date that his predecessor's term of office expires, whichever is the latter. On 23rd November 2012, President Kuruma was re-elected President. His second 5-year term began as of that date. It expired as of 23rd November 2017. The period during which the election of his successor was to be held is provided for in Section 43. Section 46(1) provides that no person shall hold office as president for more than 2 terms of 5 years each, whether or not the terms are consecutive. As such, he was not eligible for re-election. Section 43 states, a presidential election shall take place A, where the office of president is to become vacant by a friction of time, and the president continues in office after the beginning of the period of 4 months ending with the date when his term of office would expire by a friction of time during the first 3 months of that period. B. In any other case during the period of 3 months beginning with the date when the office of president becomes vacant. Paragraph A works out as follows. The period of 4 months contemplated was 23rd July to 23rd November. Accordingly, if I have read the paragraph correctly, the presidential election should have been held within the first 3 months of that 4-month period, that is, between July and 23rd October 2017. But paragraph B contemplates an addition to the 5-year period. It contemplates a 3-month period beginning with 23rd November. That period evidently ended on 23rd February 2018. The election held on 7th March 2018 was a date which was already outside that 3-month window. The vacuum in the seat of power, which the 1991 Constitution was trying to avoid, became an eventuality. Mr. Ibrahim Sorie Kamara's intervention, if successful, would have extended or rather enlarged the vacuum. It may safely be assumed that the drafters of the 1991 Constitution never had this eventuality in mind. The paramount consideration in 1991 was to ensure that there was a smooth transition from a one-party form of government to political pluralism. To return to the orders prayed for by the applicants in their originating notice of motion, the 1991 Constitution confers on this court supervisory jurisdiction over other subordinate courts. Section 125 of the 1991 Constitution states, the Supreme Court shall have supervisory jurisdiction over all other courts in Sierra Leone and over any adjudicating authority. And in exercise of its supervisory jurisdiction shall have power to issue such directions, orders or writs, including writs of habeas corpus, orders of certiorari, mandamus, and prohibition as it may consider appropriate for the purposes of enforcing or securing the enforcement of its supervisory powers. The supervisory power conferred on this court has been exercised on several occasions and in several cases. Some of these cases have been cited by Mr. Taylor in the course of argument. This court is seized of the reasons for the decisions in those cases and will follow the trend set in those cases. Whenever a subordinate court has acted ultra vires or has exceeded its jurisdiction in such a way as to create injustice or uncertainty in the law, this court will quash any decision flowing from the wrongful exercise of jurisdiction. In the result, this court makes the following orders. This honorable court issues the order of certiorari quashing 1. First, the decision of the High Court, the Honorable Mr. Justice Mansari presiding, made on Saturday, 24th March 2018, in which decision 2 orders were made, to wit: 1. Paragraph 13 of the ruling delivered on Saturday, 24th March, wherein the learned judge held, for the above stated reasons and having answered in the affirmative that this court has jurisdiction to hear and determine the originating notice of motion, this court hereby refuses and rejects the objection of the first and second defendants hearing. And 2. Paragraph 1 of a subsequent ruling made the same day, that is Saturday, 24th March 2018, when the learned judge granted an interim injunction restraining the first and second defendants from conducting the runoff presidential election scheduled for 27th March 2018, pending the hearing and determination of the application made to that court by the respondent in the application in this court. 2. Now that's the second order. Second, the decision of the High Court, the Honorable Mr. Justice Mansari presiding, made on Monday, 26th March 2018, in which 9 orders were made by the learned judge relating to the holding and conduct of the pending runoff presidential election, save that numbered 1, in which the interim injunction restraining the applicants therein from conducting the runoff presidential election on March 27th, should be capital M, March 27th, 2018 was vacated. And the third order this court makes is that the respondent shall pay the cost of this application to the applicants, such costs to be taxed if not agreed.
I agree.
I agree.
Copies of the judgment will be made available in the next hour after I've done the corrections. I'm sorry, Miss. Okay, you are covered up, so I wasn't too sure. I wasn't sure who was looking at. So I'll enter your name on the record. Sorry, the affidavit of service is in respect of Mr. Koma or Mr. Dumbuya? The affidavit of service. Okay.
see on Koma.
I'm sorry? On Mr. Kuma as well. I see. But Mr. Jefferson. Yes, sorry, yes. No, definitely.
Mr. Jefferson, when you say you personally served
I always hold you responsible when it has to do with Jefferson.
No, the notices had already been sent. What you needed to do was update council about the change of time. There was no point in sending another notice when one had already been sent. It's simply, all you simply needed to do was to send a text or WhatsApp message. You do that for all other nonsense things anyway, so you could have done it for something that's important.
And I always hold you responsible when it has to do with what they've done and check.
You run the office.
Including the affidavit says you serve personally by delivering it with, in her case you said with his secretary. That's what Jefferson put. You should have looked at all of that. Just read it and you see what I'm talking about.
I think we are going to have it printed out, corrections made, and then I'll send them around again. Yeah, this is yours. That one is yours. So I'll send them around again for signature. Let me just do the corrections. I'll get Miss Samuel to finish them off. Thank you, gentlemen, ladies. So you have the last order, may cost to be taxed if not agreed. All right.
on Initiative Africa. My name is Asha. Welcome to this new edition of your weekly magazine featuring Africa on the move through smart innovations and initiatives that work. Let's get on with the show with our top stories today. We meet Safiatou Gueye, a Franco-Senegalese determined to preserve the beautiful tradition of Wolof nursery rhymes and